Hello, hello, hello. What's all this then? What am I talking about? You may have seen in the news that the Fire Brigades Union has put out a statement saying that their members, in other words, firefighters, will not assist the police in evicting protesters. And that's caused some discussion as to, well, isn't it an offence not to help the police when asked? And the answer is yes, but. So what I need to do is to give you the sort of full history of this, and this rather convoluted but quite interesting subject, is take you back to 1285 and something called the Statute of Winchester. Now at the time, we didn't really have a sort of a full-time police force, but individual areas had sheriffs, or sheriffs as they became known, and they were responsible for sort of, law and order. So what if you had a felon or a miscreant? Well, it used to be that they would just ask them to come and be arrested. It was like they were effectively summonsed. But obviously not everybody was willing to comply with that, and they would go on the lam. And it used to be that each particular area, they were only really concerned with their own area. And it was like, well, as long as they've gone somewhere else, do we really care about it? I mean, you get these things, just to go off a little aside, the Halifax gibbet, or gibbet, the big sort of proto-guillotine thing. The myth there was that they would get people, they would put them, getting ready to chop their head off. But if they could escape and run and cross a particular beck, that's a type of like stream in Yorkshire, then they'd let them go, and effectively, so long as they never came back into the parish or the area, then that'd be the last they heard of it. Now, I did look into this because I was wondering how many, did they just do that to scare people? It's like, yeah, we'll put him there, let him do a runner, and we'll never see him again, and that's the end of the problem. Having said that, lots of people, the guillotine, well, the gibbet did work on them. But there was this idea that it was somebody else's problem. But King Edward said, well, no, this isn't, this is a bit of a recipe for anarchy. So in the statute, it codified the concept of the hue and cry. Now, the hue and cry had probably existed before then, but this sort of set out in writing exactly how it worked. So, if you got somebody who refused to surrender to the sheriff, it says the following: and if they will not suffer themselves to be arrested, let hue and cry be raised against them, and those who keep watch shall follow them, with the whole vill, together with neighbouring vills, with hue and cry from vill to vill, until they are taken and handed over to the sheriff, as is aforesaid. And for the arrest of such strangers, no one shall have legal proceedings taken against him. In other words, it sort of said, right, you have a duty for everybody, in the town, not just the sort of people being paid to be watch people and things. I mean, the statute's fantastic. It's got all the stuff about when you close the town gates, how the markets work. It's one of these where you get the myth that you're allowed to use a bow and arrow against people, as long as it's within city limits in daylight. That's definitely been abolished, by the way, now. This entire statute has been abolished, so please don't go around getting your bow and arrow out just because people look suspect. But you'll note there it said, right, everybody has to do this. You are under a duty. I mean, the statute goes into sort of what weapons people had to carry. I mean, it's interesting now that we're sort of quite an anti-weapon country, but at the time, it gave a list of what your sort of income was and what your holdings were, how much you were worth. And it said, right, if you're worth X amount, then you must at least have this. If you've got this, then you must at least have this. Whether it was like, okay, you can just have a pike because you're quite poor, but hey, you've got loads of money, you should at least get an axe. And wow, you're minted. Sword and full sword, suit of armour for you, matey boy. But you'll note that it gave immunity to anybody who did arrest the person. That was pretty much the law up until the Metropolitan Police Act in the 19th century. I mean, there was also, in the intervening times, there was a Sheriff's Act, but that more or less just codified and carried on with the concept of the hue and cry. So then we got the Police Act, the Metropolitan Police Act, and that abolished all the previous stuff. But the argument was, it was still a common law offence not to assist a constable when required. But I've been looking into this, and it's interesting that there aren't that many cases on it. But first of all, what is the offence? Well, like I say, it's a common law offence, so this definition has arisen from all the case law. It's not set down in the statute anywhere. But It is an offence under common law to refuse to aid or assist a constable in the execution of his duty of maintaining or restoring the Queen's or King's peace when called upon to do so, if that person is physically capable of rendering such help and has no lawful excuse for so refusing. Okay, so that's the actual offence, but what does that mean in practice? There's a case of Crown and Brown. No, not that one, law students. This was in 1841. And in that case, it was held that when a defendant was requested to assist an officer to quell a riot, it was necessary to prove that the constable had witnessed a breach of the peace being committed, that it was reasonably necessary for the officer to call on the defendant for his assistance, and that the defendant had no physical or lawful excuse for his refusal. So you'll see there, it's a case of, you have to establish that, the help is necessary, that there's something going on, and the police officer knows something's going on. And we'll come back to this theme that it has to be sort of an imminent danger, something that's occurring at the time. There's a further case, Crown and Sherlock in 1866. And that stated that refusing to assist a constable in the execution of his duty and prevent him being assaulted by the persons in his custody in order to facilitate their escape was sufficient without having to show how the arrest had become lawful. It was also sufficient to show that the person refused to assist without having to show whether or not he did in fact assist. So two things there. First of all, you can't stand there and say, well, officer, I'm not just going to take your word for it that you have the right to arrest this person. Explain to me that this is a lawful arrest and this is an arrestable offence. It's like, no, if the copper says, give me a hand to grab this guy, mate, you have to. And also, it's the refusal that's the offence. So if you say, no way, I'm not helping, but then you do, technically speaking, you have actually committed the offence. Although, like I said, there's so few cases on this, it seems to be something that doesn't crop up a lot. The most recent I've been able to find is Crown and War from 1956. And that was somebody, he was a London Transport ticket inspector. And he, it kicked off in the ticket hall and the police said, can you give us a hand here? And he said, I'm not getting involved, mate. And he was successfully prosecuted. But the scope of the citizen's duty to assist seems to be limited to the conditions set out in Crown and Brown above. Couldn't find any cases that suggest that the duty extends beyond preserving the peace, though. This is something I'll come back to. Indeed, the courts have firmly and repeatedly stated that it is neither an offence nor an obstruction of the police in the execution of their duty to refuse to help with police inquiries, for instance. That's from a case called Rice and Connolly in 1966. The general statement is subject to various specific statutory duties, though, to report suspicion of crime and give information in relation to certain offences. So, for instance, you have to assist if it's a terrorism inquiry, also certain drug trafficking offences. So, generally speaking, just to clarify the difference, there's no offence of refusing to assist the police, but is an offence to obstruct somebody. So, if, for instance, the police say, they suspect you know where somebody is they're looking for. Tell us where Joe Bloggs is. I'm not telling you. That's not an offence. Is Joe Bloggs in the house? No, he's not. That is an offence if he is in the house because you've actively told an untruth. Or if you give them and say he went that away when in fact he went that away, that would be the offence. But if you just fold your arms and say, I'm not telling you, mate. So you'll see there that it's this idea that there's got to be an imminent threat. So if the police say, right, we're off to arrest some top gangster and we'd rather not do it, so can you go in there and arrest him for us? That wouldn't be an offence, it's got to, the idea is that you are preserving the peace. So it's an active situation where the police are trying to arrest somebody and it's all kicking off and they need to arrest them there and then, and that's when they can call for your help. But if it's just a situation where, say for instance, on a protest, one of these where the police have made the decision, as they often do, we won't arrest them now because it'll all kick off. We'll take photographs and then we'll go around, we know they are, we'll go around and arrest them later. They couldn't ask you to come and help them arrest them later. But let's say, for instance, now they've sort of toughened up a little bit, the police, and they're actually doing the snatching ideas, where you just go in, grab the person, get them out very quickly. And it kicked off there. Well, theoretically, in that situation, if they asked you, Because if somebody's struggling and there's loads of people around, then that's a breach of the peace being, occurring at the time. So in those situations, you would be expected to assist. On a related note, what if you see movies where people, the police suddenly flag down a car and go, "I need your vehicle, get out of the car, I've got to chase this person." Or they jump in your car and say, "Follow that car." Is there any power to do that? Well, this was investigated, and because people at the time, obviously when the Hue and, the statutes were written, we didn't have cars or even bicycles. So it didn't really, occur to anybody. But we looked at this sort of in the advent of cars. And it was very interesting because the only thing we could find on it was there was a parliamentary inquiry in 1925. Where they looked into, had this actually ever occurred? And if so, what was the outcome? And interestingly, they found about 30 cases where this had actually happened. And what was interesting is, in 3 of the cases, the vehicle had subsequently been damaged. Although only one of the owners actually went after the police and said, "Oh, you pay for that." And the debate was whether they had to pay the damages. And part of the argument was, they were saying, well, no, because it's your duty to assist, arguably, the police aren't expected to compensate you for any damage. If you wanted to chase compensation, you'd have to go after the person that you were assisting in trying to arrest. But like I say, it was interesting. I haven't seen any more recent ones, but obviously probably not a lot of cars around in 1925. So to have 30 known instances suggests that the police were doing this. But I suppose back then they themselves didn't have vehicles. They were all on foot patrol, so it might have well been, but we need to get somewhere quickly. Let's flag down one of these newfangled motor vehicles. Now they've all got cars of their own. It's probably less of an issue. But the Parliament said there's probably no duty to actually let the police borrow your car or to jump in and ask you to chase people. Although, interesting, when looking at this, quite a lot of cab drivers said, yeah, we've had the cliched follow that car thing. Police have just jumped in the car and said follow that one. So it does actually occur. But yes, you're under no legal obligation to let the police use your car. I did actually another video going into a bit more depth about that. So I'll move over here and I'll point to it because I'll do it as like one of those things where you can click and watch the video. Although I'll be totally honest with you. Basically, it doesn't go into much more than what I've just said there. But yeah, so with this thing with the Fire Brigades Union, arguably refusing to assist in just evicting protesters, well, that doesn't fall within any way, because unless they're kicking off, there's no immediate threat of breach of the peace. It could well be if they were protesting, they're about to vandalise something or about to storm a building or kick off, then arguably could say, well, a breach of the peace is occurring, so therefore the duty would apply. But if it's just a case of, here's a bunch of people doing a sit-in, and while it's a disruptive protest, it's not a sort of violent protest and it's not breaching the peace, then arguably nobody, including the fire brigade, would be under any obligation anyway as a matter of law to assist them. So as always, hope you found that vaguely interesting, vaguely useful, vaguely accurate, and I will see you next time.